to our friends and viewers around the world. My name is Olayinka Dansalami. I am your host. Welcome to Know Your Right on NABN TV, a program that provides you general information about your constitutional right in the United States of America. The U.S. Constitution provides certain rights to all those residing in the United States. Whether you are dealing with immigration, housing, employment, charge you with a crime, you are entitled to some basic constitutional right. Today, we will touch on immigration. To help us to navigate this very important topic, we have in our studio Carla Prosper. Welcome back. Okay. Let's say that someone is filing for his or her spouse, and that spouse is not inspected.
Okay.
What is the process? And please also explain to our viewer, what we mean when we talk about not inspected.
Yes, not inspected is a legal term. Not inspected is a term used for people who do not enter the United States with a visa or a parole document. They either come through the border and have no admission. They were not admitted or inspected by an immigration officer. Those cases are a little tricky because those applicants either have to file consular process, they do not qualify for adjustment of status, or they have to qualify under a law which is becoming older by the day called 245I. 245I was a law which was last enacted in 2001, and it allowed certain beneficiaries of I-130s or I-140s, which are work petitions that were filed before April 30th, 2001, to obtain their green card in the United States, although they have an unlawful entry or were admitted without inspection. But they had to pay a fine of $1,000 and prove that they were physically present in the United States when the law was enacted. So this law, of course, it hasn't been renewed, so you find less and less people qualify for this. However, if you speak to an experienced immigration experienced immigration attorney, there are different ways to see if individuals qualify for this. Most recently, I had a client whose father was granted a green card in the 90s when he was a child.
Very interesting.
And as a result of that, he qualifies under 245I because he would have been a derivative of the petition that was filed by his grandfather for his dad. I know it's a little confusing, but sometimes you have to dig deeper to see if there are ways to qualify under 245I.
Is that what we call that person is grandfathered?
Grandfathered, correct.
That's interesting.
Yes,
that's interesting. I think this will be a very important information for our viewers. So, but now, let's say, for argument's sake now, that a U.S. citizen petition for his brother. Tell us, how long does it take, for that brother to adjust if the brother was not inspected?
So, if the brother was not inspected and is living in the United States, and his U.S. citizen brother filed a petition for him, first of all, if you are not Mexican, Filipino, or Indian, the wait is about 12 years. For those other countries I mentioned, it can be up to 20 years.
What?
Yes. They have a higher demand to come to the United States, so it takes a little longer.
Why is it that long? Is that because, there are certain quotas, certain numbers
yes,
given to a certain country?
Exactly. There's a demand for Chinese, Indian, Filipino citizens, the wait is longer. It's because some formula the government came up with, and additionally, there's more of a demand from those countries. Did I state Mexico also? And so the wait is a lot longer. It could be up to 20 years for a brother petition from Mexico.
So what for our community? When I say our community, I'm talking about the Nigerian African community. So What is the waiting period for that communities?
So technically for people from the African countries, there is no specific quota. There's no country-specific quota. It would be in the general column.
Of 12 years.
Of 12 years. So when you look at the visa bulletin, which gives a forecast of how many Immigrants can come in under certain family-based categories. There's a general category, and then there's a category for the different countries I mentioned, such as India, Mexico, China. So every country which isn't listed specifically would fall within the general wait list.
So you talk about a visa bulletin. Is this something that anyone can go into and then look at his his or her priority date?
Absolutely. The Department of State every month issues the visa bulletin, and it's very easy to find. You can even Google Department of State visa bulletin. It's usually issued at the end of the month. For example, around the 20th of a certain month. So we already have the numbers for the following month. You understand?
Right.
So, and it's very easy to find, and there you can see what the wait is approximately for obtaining a visa.
Thank you very much. So, Carla, let's say for argument's sake that, I have all my papers, I want to file for my spouse, I'm a U.S. citizen, but I'm not making enough money. Where does that place me?
So, every green card applicant must prove that they have financial backing, so to say. The applications for your green card, whether you file it here as adjustment of status or the consular, request that you submit an affidavit of support, which proves that you will not be a public charge.
Okay.
So many times the petitioners, the U.S. citizen requesting their family member, do not have enough income to support the incoming family member. So they have to obtain what's called a co-sponsor. The co-sponsor will have to meet the 125% of the poverty guideline. Just to give you an example, and every year it changes, so that's something you can look up on the USCIS website. For example, a family of 3 has to earn about $22,000 a year. So depending on your co-sponsor's family size, you will know how much income they have to earn to qualify as a co-sponsor.
So is that what we are referring to as public charge?
Well, in this administration recently has decided to take the affidavits of support requirements a little further. Recently, they published an additional form, the I-944, which has 18 pages, and it's an affidavit which requests a proof that the incoming green card holders will not be public charges. The form requests, amongst other things, a credit report, income, budgeting, health status, but this application is currently in litigation. In the New York State, there's been what is called an injunction, a stop on this form. And so as of now, we are not required to file that 18-page document with any adjustment of status or consular processing.
So our viewer can be at rest, if they have not actually filed their petition, because we have some people who said, I have to put on my petition before October 15. So is that correct, or this is just a myth?
Well, this is a myth currently. The thing is, immigration law is living and it's changing every day. So the form, they are correct because the form did come out around October 13, 14, but there was quickly an injunction placed on the form. So as of now, they can go ahead and file as they would have pre-October 15. Keeping in mind that updates are always posted on uscis.gov, and there may be another change in the law. That's another thing that immigration attorneys are charged with, always keeping up to date with the changes of law. And I recommend that our viewers do the same, because filing the wrong form could be detrimental to your case.
Please subscribe to our YouTube channel, like us on Facebook, follow us on Instagram. We are also on Twitter. If you want to support any of our programs, please send us an email, nabntv@gmail.com, or visit our website at www.nabntv.com.
Welcome back. Carla, you are talking about credit history. So what does that have to do with someone who is financially sound but has a bad credit?
Well, the new public charge rule wants to look at age, health, family status, assets, resources, financial status, and educational skills. So I believe the administration is using the credit history to see if the individual's financial status and resources, and how whether or not that establishes that the immigrants he or she is petitioning for will request public assistance. So it's just another instrument that the government may use to either disqualify or qualify an alien for their green card.
When we are talking about public assistance, can you tell us, what does that entail? Does that entail, for someone who is sick, went to the hospital, and now was able to get treatment, but then has now paid for that services? Would that be considered as receiving public fund?
So the public charge rule is specifically looking at cash benefits received, and if the cash benefits are going to be something that the immigrant is going to receive and rely on in the long term. Now, there can be one family member that does get cash benefits, but the concern is the whole family relying on those cash benefits, or is this an incident where one individual in the family needs these benefits, they're a U.S. citizen, versus the whole family is going to try to mooch off the system and use them. Another thing that they're looking at is, and I think this may affect the older population of applying for green cards, whether there's a potential of long-term institutionalization for healthcare issues. So this could affect our elderly population who's looking for green cards, and a consular officer may deem that they're a person who will end up in a nursing home and use up American systems. But in direct response to what you said, what you requested, usually emergent Medicaid or Medicare programs are not considered public assistance. If there's an emergency and you have to have a gallbladder taken out, or you're in a car accident, that usually isn't used against you for a public charge. But welfare, cash benefits, Section 8, these are things that may all be considered.
So for someone who applied for Medicaid, that cannot be used against him or her. Is that correct?
Well, if it's emergency, it shouldn't be used against them. But I think that one of the things the public charge rule tends to overlook is how difficult it is to get these type of benefits. Usually, the government, state agencies want to see that the individual has 40 years of work credit, 40 quarters of work credits from the Social Security, that they are U.S. citizens or permanent residents. I think that the public charge is a little misguided in that anyone could just go up into a office for public assistance and receive it. So if you do qualify for these programs, it shouldn't affect you. The government's really going after people who they believe will try to obtain the program without having the proper, without having had contributed to the American economy.
Carla, let's say for argument's sake that we have a 25 years old non-U.S. citizen who married a U.S. citizen, and the first application that he filed was denied based on lack of funds by the petitioner. Can the non-immigrant, can his or her 18 years old petition for him or her? If the first application that was filed by a U.S. citizen married spouse was denied?
Well, of course, they could file another petition. However, the child would have to be 21 and over. Because remember, in immigration, 21 and younger is considered a child, and a child cannot petition for their parent, but a adult U.S. citizen can. So any son or daughter who is over 21 can petition for their parent.
So will it be a misleading information to our viewers who believe that my 18 years old child can file for me?
That's completely false. Yes, that is misleading. The child, the son or daughter, has to be 21-year-old or older to petition for a parent.
That's interesting. So now let's also say that a non-U.S. citizen who filed under 245I
Yes.
petition,
Okay.
let's say that, that petition was approved. No, let's say the petition was denied.
Okay, the first petition denied.
The first petition was denied.
Yes.
Subsequently, this person now filed again, but that petition was approved. Can the first petition, can it be grandfathered, to the one that was approved?
It depends. So just because the first petition was denied doesn't mean that the individual won't qualify for 245I, but immigration will challenge the first petition. You will have to establish that it was what they call, and it's a term of law, meritorious in fact, that it wasn't fraudulent, that it was filed on proper grounds, and that it was approvable when filed. That means that when they filed the petition, it was proper, there was a marriage, or there was a proper job opportunity, and immigration will challenge the denial. So you may have to explain the denial to USCIS, even though it's very old, so that you could benefit from the first petition under 245I.
Can you go through it again with our viewers? When you say meritorious in fact, can you please explain that again to our viewers so that they can understand what you are actually talking about?
Okay. Meritorious in fact means that the petition was filed on proper grounds. An example I could give is that if it was a petition for work, it was a proper job opportunity, but it was later denied maybe for a technicality. But the job existed and the employer was willing to pay the employee. That's one example. Another example is that if it was a petition that was done and it was denied, like actually this could tie into the first scenario, but it was the adjustment was denied for an affidavit of support, but it was a proper marriage. Maybe a document wasn't submitted and it was denied. So you have to prove that it was meritorious in fact. It wasn't an 18-year-old filing for a parent. Understand? It wasn't a person who was married already filing for a spouse.
What if a brother and say, what if it is a brother and sister filing and immigration request for further information? When they send their request for additional, they request for additional information about the relationship. Okay. And they were unable to furnish this information
at the time,
and it was then denied on that ground.
So,
will you consider that to be meritorious in fact, but it was denied?
Well, so it had to be approvable when filed. So the fact that it was missing some documents, you'll have to explain that. It depends on what documents. Were they preliminary documents that should have been submitted at the onset, or were they technicalities? So I think they have an argument there, and there's a way to present it to properly be grandfathered.
Now, let's say someone who filed a petition under I-130-485, married to a spouse, and that petition was denied based on some sort of fraud. Immigration determined that the marriage was not legit. Mm-hmm. And the person subsequently married, to another person who is actually his or her spouse. Can this person now file again, and what do you think immigration will do with that petition?
If there was an actual finding of fraud on the first petition, what's called a 204C finding, then the alien is barred from ever being the beneficiary of a petition in the future. So that's a very strong finding. If there's fraud in the first marriage, it'll affect all other petitions.
So, explain to us, when you say fraud, is it final, when you say finding of fraud, is that final? Can that be appealed? What if there was some sort of error, mistake, thinking that, I actually married this lady, but then something happened and then I can't find her again. She disappeared. And then immigration, for some strange reason, they believe that it was fraudulent. Does the finding of fraud, is that final?
So if there is a finding of fraud determination, in New York and New Jersey, there's what's called a Stokes interview. You're usually getting 2 bites at the apple, where you're interviewed once very simply. But if there's any doubt, the immigration officer may schedule you for a second interview where you may be separated, you may be recorded and taped. The officers evaluate the statements, and if there are a lot of discrepancies, they may either say you haven't met your burden, which is not fraud, or they may make a finding of fraud. At times, immigration officers also do home visits. They may ask your neighbors about you, may ask your coworkers. They may come to your home, ask, where are the dirty clothes? Where are the shoes? So sometimes if after a home visit, there's some evidence to there being a fraudulent relationship, you may be branded as having entered into a fraudulent marriage. The decision is usually served by mail, and the applicant will have 15 days to submit an appeal or a motion to reopen. You must really look at the instructions on the letter because it will tell you how to appeal it. I suggest if there is a finding of fraud, you should 100% definitely, I don't know how many times I could say this, challenge it.
Okay.
Because it does affect you in the future.
That's it. Thank you very much, Carla. Do you have any suggestion or advice, to our viewers who are trying to file for their family members, either in the United States or outside the country?
Yes, my advice to them would be to be very knowledgeable, do a lot of research, speak to professionals. There's a lot of immigration attorneys that you could file through the American Immigration Lawyers Association who could give you precise advice, because these days nothing is simple. There's a lot of catch-22s. People tend to think immigration is just filing forms, but each form is a breakdown of the law and how it applies to you. And I was always taught that immigration is a law of exclusion. And a lot of times it's, the government's trying to exclude people from coming in. So you really do need to get a knowledgeable attorney or seek advice from someone who has been registered as an immigration organization, and explain your situation to see if you qualify and if you're able to come into the United States.
If some of our viewers wants to get hold of you, where can they reach you?
The best way to reach me is on my website. We have a contact page. It's at carlacprosper.com. And that's carlacprosper.com. And there you could drop us an email. You could put on in a contact page, and we'll be sure to get back to you as soon as possible. And if you have a WhatsApp number, you could also leave that, and we could also schedule consultations. But please send us an email, and we'd love to hear from you and try to help you.
Thank you very much, Carla.
You're welcome.
Thank you for watching us today on Know Your Right on NABN TV. During the next show, we will continue the topic of your rights under immigration law, and we will discuss some of the employment-based green card and deportation. We would like to take this opportunity to appeal to you to advertise your product and be one of our sponsors so that we can continue to disseminate important information about the rights that you have under United States Constitution and other federal and state law. Your right when an immigration officer knocks on your door, your right when the police officer stops you. Information is power. We would like to equip you with the sufficient information and dispel the misinformation and myth that may be going on in our community. We also hope to allay the fear of some of you when it comes to the law. Please stay tuned. Finally, please know that this is a program that has not created any attorney-client relationship. If you have a legal matter or pending case, it is better to review all of the facts and circumstances of your particular situation with an attorney in order to determine the best course of action. You may contact any guest or any other attorney for further consultation if you wish. Neither NABN TV nor its host is liable for any consultation you may have with any guest of this show. We are merely providing you general information. Thank you for watching us. Please stay tuned. We'll be back in the next week.